All of us have individual rights and freedoms that belong to us simply because we are who we are, human beings, men and women. There are principles and laws that are in operation which are there for the benefit and protection of the individual. Right now, most are being governed and controlled by laws which have been created by the government and which impact our life. Now, law is the regime that orders human activities and relations through systematic application of the force of politically organized society or through social pressure, backed by force in such a society, the legal system. Again, we hear respect and obey the laws. So within law, we find natural rights. So all of us, you and me, men and women, we possess natural rights. And these are rights that are conceived as part of natural law and that is therefore thought to exist independently of rights created by the government or society, such as the right to life, liberty, and property. So individuals have rights and freedoms. These rights and freedoms exist apart from legislative law or enactments. They are better known as natural rights, common law rights, fundamental rights and freedoms, or human rights, and they are not created by the government. There are natural human rights and freedoms that are in operation for all of us to exercise and stand under. These rights and freedoms are not created by the government, but they are recognized by the government. Many of us are not aware of the fact that there are rights and freedoms that exist for us to use and stand under, which are not given or created for us by the government bodies. Mankind had already witnessed the tyranny of several dictators in the early 1900s, several men who caused strife and trouble worldwide. This strife and trouble led to several world wars and the death of millions and millions of individuals. The world was witnessing and had witnessed the destructive power that the government body can yield when it becomes too big and too powerful. The Universal Declaration on Human Rights, along with the subsequent International Bill on Human Rights, was introduced as a mechanism to be followed and used to prevent the outcomes of the past, to prevent any one government from obtaining authority and power over an individual. Until this time in mankind's history, the law of the nation where the individual resided was to govern the individual. The domestic laws that were created bound individuals to obey their governments, even if the laws that the government were creating were tyrannical, even if the laws limited or denied natural rights and freedoms, common law rights, fundamental rights and freedoms. The more power a government had, the more it could subject its citizens and the individuals on the territory to submit to their laws. There was no mechanism available to speak back, to take a stand, or to fight back. Now this changed with the implementation of the international covenants. This is where our rights as individuals became internationally recognized and became domestically recognized on our state party. So why does America, federal and state, and every subsequent state have the obligation to allow you to exercise your natural rights, your common law rights, your fundamental rights and freedoms, better known as the rights and freedoms found in international covenants? America signed the covenant and ratified it in 1992 with reservations. Now these fundamental rights and freedoms, they pre-exist all. The international covenant did not create these rights and freedoms. The international covenants only recognize these rights and freedoms and place a legal obligation upon our countries, upon the government of our countries, of America, Canada, and Russia, to respect our rights, not to limit our natural rights, and to make sure that their expression is found in domestic law. Now, these rights are brought forth through the United States Constitution, specifically Article 6, Clause 2 of the Supremacy Clause. So this is the mechanism of law that they used, Article 6, Clause 2 of the Supremacy Clause, to bring in the international covenants into the Constitution Act of the United States of America. And the obligation that was resting upon the government of America came directly from the International Covenant, Article 2, where it states, where not already provided for by existing legislative or other measures, each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional process, so you see it there, and with the provisions of the present covenant. So there's the legal obligation. There is rights and freedoms that are expressed in the covenant. There are provisions in the covenant, and you, state party America, you have to bring these forced through your constitutional process, and you have to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. So the legal obligation upon America is they have to give effect to the rights recognized in the present covenant, and they have to do it through a constitutional process to adopt such laws or other measures. So they have three ways of doing it. Now, the controlling medium is the international covenants. The rights and freedoms expressed in the covenants binds America. The rights and freedoms brought forth through the constitutional process, or these rights and freedoms must be brought forth through the constitutional process. This is an obligation upon the United States, upon America. They have no choice. They have to do it. That's exactly why they did it, through Article 6, Clause 2 of the Supremacy Clause. They're fulfilling their legal obligation. Further to this, in the International Covenant on Civil and Political Rights, Article 5, it says nothing in the present covenant may be interpreted as implying for any state, the United States of America, group or person, any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms recognized herein, or at their limitation to a greater extent than is provided for in the present covenant. Again, we are seeing that the controlling mechanism concerning how America and Canada and all signatories to these covenants can create laws. It is governed by the international covenants. America cannot limit an individual's rights and freedoms apart from what international covenant allows it to do. America and all state parties are under obligation to follow the international covenants. The covenants are the control mechanism that governs domestic laws. They cannot limit human rights and freedoms unless it is in accordance with the covenant. They cannot just make up laws and regulations that go against your fundamental natural rights and freedoms. There always has to be a provision, a measure in place that allows you to exercise those inalienable rights. Remember, the obligation upon America or Canada is to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. The obligation comes out of the covenant itself when we look at the article of law. Together, these articles of law produce the obligation on the executive powers of the USA. They must make provisions to give effect to the rights, and they must not take actions aimed at the destruction or limitation of the rights. Combining these articles of law together, then subsequently bringing forth the domestic applications, brings forth the picture clearly, and this must be done. Simply stating that there is obligation without showing why is not strong enough. U.S. reservations, declarations, and understandings concerning the International Covenant on Civil and Political Rights. Now, it was the Senate's advice and consent, subject to the following understandings, which shall apply to the obligations of the United States under this covenant. That the United States understands that this covenant shall be implemented by the federal government to the extent that it exercises legislative and judicial jurisdiction over the matters covered therein. So there's the obligation through your own constitutional act that says the federal government has the obligation to respect and implement this covenant, and otherwise by the state and local governments, to the extent that the state and local governments exercise jurisdiction over such matters. So if it's a state regulation or enactment, the state has the obligation to respect your rights. If it's a federal enactment, then the federal government has the obligation to respect your rights. Why? Because they have to implement this for the fulfillment of the covenant rights. And they went and they made a reservation. The Senate's advice and consent is subject to the following declarations: that the United States declares that the provisions of Article 1 through 27 of the covenant are not self-executing. So they said, yes, we have the obligation to respect and implement your rights, and this obligation falls upon the federal government, and it falls upon the state government, and it falls upon the local governments, and we will do our part to fulfill the covenant concerning your natural fundamental rights and freedoms, but these rights and freedoms are not self-executing. So it's only when you approach the executive powers of the state or of the federal government and say, I have certain rights and freedoms under Article 1 through 27 of the Covenant, more than that, and they are not self-executing, and now I'm here before you seeking to exercise my rights. Again, now we look back into the International Covenant on Civil and Political Rights, Article 2, where that obligation comes upon America. And it states, we're not already provided for by existing legislative or other measures. So it's possible already that some of these rights and freedoms, some of our natural rights, some of our common law rights, some of our human rights have already been expressed in domestic law prior to the international covenants. And here it's saying we're not already provided for by existing legislative or other measures. Then you have the obligation, in accordance with your constitutional process and with the provisions of the covenant, to adopt new laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. So when we look into the domestic law of the United States of America, we're going to find that some of the rights and freedoms that are expressed in the covenant had already been expressed in Americans' domestic law prior to their obligation falling upon them. If the fundamental natural rights and freedoms that are brought forth in the covenants do not exist in America or Canada or any other state party, the executive powers of the state is under obligation to provide operations of law to enforce these rights. When we look into the state constitutions, we will find that these constitutions are bringing forth operations of law that respect our common law rights, our fundamental rights and freedoms. There is provision and mechanism of law available for the individual to enforce their rights. These provisions flow out of international law, the international covenants, through the Constitution Acts, and subsequently into the justice system, the judiciary, through the administration of justice. This is what you term or designate when you are seeking to enforce your fundamental right or freedom, your common law right, your natural right. You are seeking the administration of justice against the state party. The superior courts in the United States of America are under obligation to take judicial notice of your natural rights and freedoms and protect them. They have the ability within their courts to produce a remedy for a violation against your inalienable rights. Now, when you look into the Constitution of Indiana, in Section 12, it states, all courts shall be open, and every person, for injury done to him in his person, property, or reputation, shall have remedy by due course of law. Justice shall be administered freely and without purchase, completely and without denial, speedily and without delay. In each state constitution, you're going to find a section that deals with this specifically. It's going to state to you that the courts are open and you can use the court to enforce your right to enforce the law. Now, they don't explain to you what laws you can enforce and what rights you can enforce, but they tell you that the courts shall be open for every person, a general statement. And when you look at the word person, we understand that the word person can be a man or a woman or the artificial. This operation of law is present in every state constitution. There is an indication that we are able to have remedy for a violation of our rights. The courts are open to us to use to seek remedy against the limitation or denial of our natural rights. And later on in this video, I'm going to get back to this topic, if you will, and I'm going to show you some of the articles of law that talk about what we are enforcing. The fact that when we go before the courts, it's our natural rights, it's our common law rights, it's our fundamental rights and freedoms that we are enforcing directly before the court. Remember that the constitutions, whether federal or state, they acknowledge, respect, and guarantee us the exercise of these natural, common law, fundamental rights and freedoms, human rights and freedoms. When you look in the Constitution Act of Canada, Article 7, it reads like this: everyone has the right to life, liberty, listen to those rights, life, liberty, and security of the person, and the right not to be deprived thereof, except through a principle of justice. Now, when you look to the Florida Constitution, in Section 2, Basic Rights, all natural persons, female and male alike, are equal before the law, and have inalienable rights, among which are the right to enjoy and defend life, liberty, and to pursue happiness. When you look into the Constitution of California, Article 1, Section 1, it says all men, see, not all citizens, all men are by nature free and independent, and have certain inalienable rights, among which are those of enjoying and defending life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining safety and happiness. The Constitution of Illinois, Section 1. All men are by nature free and independent, and have certain inherent and inalienable rights, among which are life, liberty, and the pursuit of happiness. To secure these rights and the protection of property, governments are instituted among men, deriving their just powers from the consent of the governed. So Illinois' Constitution sums it up very well. What's the purpose of government? The purpose of government was to secure these rights. What rights are they talking about? Our natural rights. You see, it said all men are by nature free and independent and have certain inherent and inalienable rights. And then they state, among which are the life, liberty, and pursuit of happiness. And they said, to secure these rights and the protection of property, governments are instituted among men. So the primary reason and the primary purpose for governments was and is to protect our natural fundamental rights and freedoms, to allow us to express them and operate them, and not to interfere with us through a commercial capacity. However, in 2016, a lot of the state parties, a lot of the government parties have realized that there is power in the executive offices to control and govern the masses. And rather than respect and ensure our fundamental rights and freedoms, they create enactments and regulations through their government powers to strip us, to restrict us, and to regulate us and to control us through their government laws. But as you see here, the reason for the creation of these governments were to protect our natural fundamental rights and freedoms. When you look into the Constitution of the Commonwealth of Pennsylvania, in Section 1, again, all citizens are born equally, no, right? All men, and women are born equally free and independent, and have certain inherent and indefeasible rights, among which are those of enjoying and defending life and liberty, of acquiring, possessing, and protecting property and reputation, and of pursuing their own happiness. In the Constitution of Alaska, in Article 1, Inherent Rights, the Constitution is dedicated to the principles that all persons have natural right to life, liberty, and pursuit of happiness. When we look into the Constitution of Ohio, Section 1, Inalienable Rights. Now look, this was dated 1851. So this was made before the international covenants were brought into existence. And here we see the expression of our natural rights, of our common law rights, of our fundamental rights and freedoms in existence already in the Constitution. The only difference now is that for the enforcement of these rights, we have to go through the administration of justice, because that's how it's been brought forth. Prior to this, no. We had certain capacities within the courts to try and enforce these rights, but now, since the implementation of the covenants, there's only certain avenues that can be used to enforce these rights. But here in the Constitution of Ohio, it says all men are, by nature, free and independent, and have certain inalienable rights, among which are those of enjoying and defending life and liberty, acquiring, possessing, and protecting property, and seeking and obtaining happiness and safety. So look, when they talk about our natural rights, they always infer or bring forth that we're supposed to be obtaining happiness, that we're supposed to be in the pursuit of happiness. But that's not what we're pursuing after. When they place us in the category of class of persons, they make our lives in the pursuit of dollar bills, in the pursuit of money. Why? Because our right to an adequate living has been removed from us. And that's not what this video is about. But when we're living in our societies, what's actually going on now is they've removed our natural right to pursue after happiness, and they're forcing us to pursue after dollar bills. They're forcing us to pursue after wealth in order to create our own security. They removed our natural rights. North Carolina Constitution. We hold it to be self-evident that all persons are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and enjoyment of the fruits of their own labor and their pursuit of happiness. Constitution of New Jersey. All persons are by nature free and independent. Now, when they use the word persons in this Constitution Act, there's been no redefinition of the word person. If you go into an enactment or regulation of a government, they redefine the word person to, to mean or to designate the artificial, the entity that's created by the government, the one who is an employee or an officer of the United States of America. But in the constitutions, there's no redefinition of the word person. So when they use the word person, it can refer to either you're standing as a man or a woman, or it could refer to the artificial. It's depending on the context that's being expressed. It is depending upon what rights are being dealt with. And since we know that in these Constitution Acts, they're dealing with natural rights, life and liberty, and possessing and protecting property, which are natural rights, we know the person being expressed is the man or woman. So all persons are by nature free and independent, and have certain natural and unalienable rights, among which are those of enjoying and defending life and liberty, of acquiring, possessing, and protecting property, and of pursuing and obtaining safety and happiness. The Constitution of Virginia. Equality and rights of men. That all citizens are by nature, no, that's not what it says. That all men. So you're seeing, I just do that on purpose to show you that they understand what they're doing, the writers of law. They don't use the designation of citizen. They don't use the capacity of citizen in their constitution when they talk about the rights and natural rights, fundamental rights, common law rights. Why? Because they only apply to us in our designation, in our capacity as men and women. That's why the subject or player always being brought forth when talking about natural rights are a man or a woman. That all men are by nature equal, equally free and independent, and have certain inherent rights. The Constitution of Indiana, Article 1, Bill of Rights, Section 1. We declare that all people are created equal. So here they didn't use the word person, neither did they use the word man, they used the word people. If you watch my other video, remember that the people can mean the inhabitants of the territory, or it can mean the incorporated person, depending on what's being mentioned, depending on what's being dealt with. And if we are dealing with rights, then when we deal with rights, the people mean the inhabitants of the territory. So we declare that all people are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness, that all power is inherent in the people. What we are clearly seeing is that there is an obligation in law, in the supreme law of the land, the Constitution acts, to respect and acknowledge inherent, natural, common law rights and freedoms, which we know as fundamental rights and freedoms. This creates a legal obligation on the government to respect our full legal capacity before them. You see, you need to know what that means, and you need to understand that designation, that term, full legal capacity. Because when you're standing as a man or a woman, you have full legal capacity. You have the power to exercise your inalienable rights. You have the power to exercise your rights and freedoms and to defend them. What the government wants to do is change you out of this full legal capacity and place you into a class of persons that is then regulated by enactments and regulations. Now, when we look to the covenants themselves, we find the following rights being enumerated. So when we look into the International Covenant, Article 8, it says, no one shall be held in servitude. And remember that this obligation, this right, no one shall be held in servitude, has to be translated, has to be brought over into domestic law through Article 2. The obligation rests upon them. Were not already provided for by existing or other measures. You, State Party America, you have to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. So here, the covenant says, no one shall be held in servitude. Constitution of the United States of America, Article 13, Section 1. We find the fulfillment of the obligation that is resting upon them from the covenant, where it says that no one shall be held in servitude. And here we see it. Neither slavery nor involuntary servitude shall exist, except as a punishment for crime, whereof the party shall have been duly convicted. Now, this is against the law. You see where they added this qualification here? if you understand what's going on, this section of the Constitution of America was created prior to the international covenants. And since then, they've never updated this section of the Constitution. But prior to the covenants, this is what the Constitution had said. And involuntary servitude was not allowed except as a punishment for crime. However, international law says that involuntary servitude no longer is allowed, period. In the international covenant, you cannot place a limit or a restriction upon that right. No one can be forced into involuntary servitude, including punishment for a crime. They used to be allowed, but they're not anymore. Now, Congress shall have power to enforce this article by appropriate legislation. Again, Constitution of Ohio, slavery and involuntary servitude. Now look, this was written in 1851. There shall be no slavery in this state, nor involuntary servitude, unless for the punishment of crime. The Constitution of Michigan, Article 1, Section 9. Neither slavery nor involuntary servitude, unless for the punishment of crime, shall ever be tolerated in this state. So what are we seeing here? We're seeing the expression again of our fundamental rights and freedoms from the international covenants coming out of the Constitution Acts of the state and the Constitution Act of America. North Carolina Constitution, slavery is forever prohibited. Involuntary servitude, except as punishment for crime, whereof the parties have been adjudged guilty, is forever prohibited. The Constitution of Indiana, Section 39. There shall be neither slavery nor involuntary servitude within the state, otherwise than for the punishment of crimes, whereof the party shall have been duly convicted. So we are seeing that this particular common law right to freedom and liberty is being preserved for us through the international covenants and subsequently expressed in the Constitution Acts. When we're talking about the right concerning involuntary servitude or servitude, this is a natural right. This is a right that is expressed through our liberty. As men and women, we have a natural right. We have the right to liberty. And we cannot be forced into involuntary servitude or into servitude to any other power, whether executive, governmental, sovereign, or individual power. Now in Article 19 of the International Covenant on Civil and Political Rights, we find the following. Everyone shall have the right to hold opinions without interference. Everyone shall have the right to freedom of expression. This right shall include freedom to seek, receive, and impart information and ideas of all kinds, regardless of frontiers, either orally, in writing, or in print, in the form of art, or through any other media of his choice. When we look, remember, this right, these freedoms have to be expressed through our Constitution Acts, and the obligation is flowing through Article 2 of the International Covenant and Article 5 of the International Covenant. So, when we look into the subsequent Constitution Acts in America, we find the Florida Constitution in Article 1, subsection 4. Freedom of speech and press. Every person may speak, write, and publish sentiments on all subjects, but shall be responsible for the abuse of that right. The Constitution of Illinois, freedom of speech. All persons may speak, write, and publish freely, being responsible for the abuse of that liberty. The Constitution of the Commonwealth of Pennsylvania, freedom of press and speech. Section 7. The printing press shall be free to every person who may undertake to examine the proceedings of the legislator or any branch of the government, and no law shall ever be made to restrain the right thereof. The free communication of thoughts and opinions is one of the invaluable rights of who? Man, and every citizen may freely speak, write, and print on any subject, being responsible for the abuse of that liberty. We keep on going. The Constitution of Michigan, Section 5. Every person may freely speak, write, express, and publish his views on all subjects, being responsible for the abuse of such right, and no law shall be enacted to restrain or abridge the liberty of speech or the press. The Constitution of Georgia, Article 24. Every individual has the right to receive freely and to disseminate information and to express and disseminate his opinion orally, in written, or any other form. So we're seeing that, again, the obligation came out internationally, and they had to express it within their domestic law. And we're looking at several Constitution Acts of America, and we find the expression of these rights, the expression of these fundamental rights being brought forth. Again, the Constitution of New Jersey, Article 6, every person may freely speak, write, and publish his sentiments on all subjects, being responsible for the abuse of that right. Constitution of Virginia, it comes out in Section 12, that the freedom of speech of the press are among the great bulwarks of liberty, and can never be restrained except by despotic governments, that any citizen may freely speak, write, publish his sentiments on all subjects, being responsible for the abuse of that right, that the General Assembly shall not pass any law abridging the freedom of speech or the press, nor the right of the people peaceably to assemble and to petition the government for the redresses of grievances. And again, in Alaska, Constitution Act, Section 5, freedom of speech. Every person may freely speak, write, and publish on all subjects, being responsible for the abuse of that right. We're going to back up here and walk through this again and look at it a little bit more closely. When you look at the International Covenant on Civil and Political Rights, Article 19, the subject or player being brought forth here is everyone. You see, it says everyone shall have the right to hold opinions without interference. Now here, the everyone, the designation law that's being used, everyone, is including both capacities. Sometimes when they use the word everyone, or most of the times when they use the word everyone, it specifically only refers to the man or the woman. And you have to discern, you have to decide based upon what rights, based upon what's being spoken about, what subject or player is being brought forth here. But since here they're using the word everyone, and this everyone shall have the right to hold opinions without interference. Now, when we look into the subsequent Constitution Acts to find the expression of these rights, we find it written like this. The Florida Constitution, Section 4, freedom of speech and press. Every person may speak, write, and publish sentiments on all subjects, but shall be responsible for the abuse of that right. So the designation, the player in law now is person. And remember, there's no redesignation of that word person. So person can either mean a man or a woman, or the artificial entity, the citizen. So you see, what's coming out is that everyone means everyone. Either the citizen or the man or the woman possess these rights. The Constitution of Illinois. All persons may speak, write, and publish freely, being responsible for the abuse of that liberty. So again, the player or subject is persons, and this can break down into two ways, the man or the woman, or the artificial, the citizen. The Constitution of the Commonwealth of Pennsylvania states it very well. It says the free communication of thoughts and opinions is one of the invaluable rights of man and citizen. So you see, they make the distinction in law. And may freely speak, write, and print on any subject, being responsible for the abuse of that liberty. So as a man, as a woman, you have a fundamental right and freedom that exists and operates under Article 19 of the ICCPR. And as a citizen of the state, as an artificial person also, you have a right that exists within the ICCPR Article 19. And it's up to you, depending on what your standing is going to be, how they will be able to limit this right of your ability to write, speak, and publish your sentiments on all subjects. So nowadays, in America, what they're trying to do, if you're operating from the capacity as citizen and you're writing against the executive governments, and you're saying and you're teaching that they're not following the Constitution Act and they're not following their obligations. Okay, most teachers out there right now, and I don't mean to be rude or mean about this, but most people who are showing forth rights and freedoms, they're bringing forth straw men. They're misrepresenting the government's position and then trying to defeat this misrepresentation to the public. But nevertheless, as citizen, they're writing and they're speaking and they're publishing their sentiments on their subjects, and then the government's trying to say, oh, you're doing terrorist activity, or you're doing activity that we are controlling or restricting or limiting through our regulations, through our enactments. However, when you stand as man, as long as you don't harm another by your speech, you have the right to write and publish your sentiments on all subjects. Again, what we are clearly seeing is the obligation on the state party to make sure that the fundamental right and freedom is expressed in domestic law, more specifically through the Constitution Act. And we saw with the rights and freedoms concerning writing and speaking and sharing our thoughts, this is a right that is being expressed in both capacities, either for the man or the woman, or subsequently for the citizen. Now let us look at another right in the International Covenant on Civil and Political Rights, Article 21. So they say the right of peaceful assembly shall be recognized. The first thing to notice is that it didn't bring forth any player of law, did it? It didn't say everyone shall have the right of peaceful assembly. It didn't say every person or every citizen. It just made a blank statement. The right of peaceful assembly shall be recognized. Now let us look into the Florida Constitution first to see what right this is applying to. Who can exercise this right? What is this bringing forth? Right to assemble. The people shall have the right to peaceably to assemble and to instruct their representatives and to petition for redress of grievances. Do you understand who they're talking about? I'll continue on. The Constitution of California. The people, so the subject or the player being brought forth is the people, and the people shall have the right to freely assemble together, to consult for the common good, to instruct their representatives. So the capacity, the standing of the people here, they have the ability to instruct their representatives. So these people had to have voted their representatives into office. Therefore, in order to vote, you have to be what? A class of persons called a citizen. Therefore, the people that is being dealt with in this section is the artificial, the citizen. That's when you go back up to Article 21, it doesn't bring forth the designation or the player, but when we look into the Constitution, we see exactly what's being brought forth. We see what right this applies to. In the Constitution of Illinois, Section 5, the people have the right to assemble in a peaceable manner and to consult for common good and to make known their opinions to their representatives. Okay, so again, we, as men and women, we do not have representatives, right? No one represents us. We represent ourselves. As a citizen, as a subject of the state, we have representatives. We have governors, senators, elected officials, and they represent us. Constitution of Ohio, the right to assemble. The people have the right to assemble together in a peaceable manner and to instruct their representatives. The Constitution of the Commonwealth of Pennsylvania, the citizens have a right of peaceable manner to assemble together for their common good and to apply to those invested with the powers of government for redress. So the Constitution of the Commonwealth of Pennsylvania really brings it forth clearly. It brings forth the designation and the player of citizen. Rather than using the term people, it actually uses the term citizen. But because we understand and we've been studying what these covenants bring forth and how they play with the words, we know that people here also means citizen because these people have representatives who they vote for. Now the Constitution of Michigan, Section 3, the people have the right of peaceable assembly to instruct their representatives. And again, we find the same thing in the North Carolina Constitution, Section 12. The people have a right to assemble together and to apply to the General Assembly for redress of grievances. Constitution of New Jersey, the people have the right to freely assemble together to make known their opinions to their representatives. Constitution of Alaska, Article 1, Section 6, the right of the people peaceably to assemble and to petition the government shall never be abridged. So I'm not too concerned with this article of law, International Covenant on Civil and Political Rights, Article 21. Why? Because whatever protection it is affording, it's only affording it to the citizen. It's only affording it to the people who are represented by their government. So you see the difference. In one article of law that we were just looking at prior, in Article 19, It brings forth both subjects and players in law. It protects the man or the woman, and it protects the citizen. And the next article of law that we dealt with only protects the citizen. And you have to learn these principles of justice. You have to learn these laws in order to understand how to stand and how to exercise your rights. So what are we seeing? International law is bringing forth the right. The obligation is placed upon our governments, our executive powers, and then we find the subsequent expression of these rights within domestic law, within our Constitution Act. Let us look at another one. International Covenant on Civil and Political Rights, Article 9. And this deals with habeas corpus. Now, in the international law, it says anyone who is deprived of his liberty by arrest or detention shall be entitled to take proceedings before a court in order that the court may decide without delay on the lawfulness of his detention and order his release if the detention is not lawful. Now, usually what transpires here is an officer of the state party, an officer of America or an officer of Canada. They will try and say that you breached an enactment or regulation, and they will try and charge you, whether it's criminally or whether it's through a civil procedure. They will try and charge you, saying you broke the enactment and regulation. And you can invoke habeas corpus to be brought before a court and have the court determine if the lawfulness of this charge or detention is correct. Meaning to say, do I owe the obligation to the enactment or not? That's the operation of habeas corpus. Now, when we look into the Constitution of Florida, we find that it's been preserved or it's been transferred for us. Habeas corpus, the writ of habeas corpus shall be granted of right, freely, and without cost. The Constitution of California, Section 5, the privilege of the writ of habeas corpus shall not be suspended. The Constitution of Illinois, Section 9, the privilege of the writ of habeas corpus shall not be suspended. So what are we seeing? Again, the operation of law internationally says you have to bring forth this right, and we see it being expressed in the Constitution. Now notice, when they're dealing with the right, they're not bringing forth any designation. They're not telling us any player or subject that this applies to. It doesn't say everyone, it doesn't say person, it doesn't say citizen. It's just simply making a general statement. The privilege of the writ of habeas corpus shall not be suspended. Unless you know what habeas corpus is and what it applies to, then you kind of lucked out, because they're not telling you and they're not teaching you who can use this. The Constitution of the Commonwealth of Pennsylvania, and it says all prisoners should be bailable by sufficient securities, unless for capital offenses, when the proof is evident of presumption great. And the privilege of the writ of habeas corpus shall not be suspended. The Constitution of Ohio, the privilege of the writ of habeas corpus shall not be suspended. The Constitution of Michigan, Section 12, the privilege of the writ of habeas corpus shall not be suspended. North Carolina Constitution, Section 21, every person restrained of his liberty is entitled to a remedy to inquire into the lawfulness thereof, and to remove the restraint if unlawful, and that remedy shall not be denied or delayed. The privilege of writ of habeas corpus shall not be suspended. What person are they talking about here? You see, in all these other Constitution Acts, they're hiding it. They didn't mention any subject or player. Now we come to North Carolina, Section 21, and you see that they bring the designation of person. And if you try to say, well, the citizen can be recognized here, you're wrong. Why? Because the citizen owes the obligation to the enactments. The citizen, as the class of person, owes the duty to the enactments. The person here only refers to the man or the woman. Why? Because when the man or the woman is restrained of his liberty, look at that, natural right, dealing with our natural right. He is entitled to a remedy and to inquire into the lawfulness thereof and to remove the restraint if it's unlawful. So they come at you, and you're a man or a woman. They say you owe an obligation, a duty to enactment. You breached the obligation. We're going to detain you. We're going to imprison you. We take away your liberty through the enactment. Liberty is a natural right that applies to a man. You have the right to invoke your writ of habeas corpus to have those charges dealt with, to see if it's unlawful against you. the Constitution of Indiana, Section 27, the privilege of the writ of habeas corpus shall not be suspended. And again, Constitution of Alaska, habeas corpus, the privilege of the writ of habeas corpus shall not be suspended. As you have seen, the controlling force against our governments is the international covenants. They must express our rights and freedoms and allow us to execute or exercise them when we stand upon them. Now, when we look into the Constitution Act, whether they be the federal or state ones, what we will not find is a direct expression of the natural rights and freedoms recognized and guaranteed to us in the covenants. These following laws are very troublesome for the state party because it deals with the control and taxation. So we saw now, I showed you, here's some laws internationally, they come out through our Constitution Act. We understand why, because there's an obligation upon the state party to do this. However, when we read these following laws in the International Covenant on Civil and Political Rights, Article 16, where you and me, as men and women, have the right to recognition everywhere as a person before the law, and a right doesn't produce an obligation, and where you and me, as peoples, have the right to freely dispose of our natural wealth and resources, and that nothing in the present covenant shall be interpreted as impairing the inherent right of all peoples to enjoy and utilize fully and freely their natural wealth and resources. When we go looking for these corresponding laws in the Constitution Acts, whether it be federally or state, we don't find them enumerated. We don't find them listed. Well, we found the other ones listed, as I just shared with you. How come we don't find these ones listed? Because these ones are very important to you. These ones are ones that allow you to exercise rights that are completely freeing concerning the commercial capacity that they are placing against you and against your life. These rights deal with contributions and taxation. These rights deal with you not having to play the role or capacity of a class of person to the government, to the executive powers. And they're hiding these rights. They're not directly expressing them in our Constitution Acts. Now, we were always taught that taxation was a contribution to the mutual benefit of society, that through our contributions, the social systems would be supported and so forth. We were taught that taxation benefits a society built upon the principle of mutual benefit. We have to do our part, goes the so-called saying. Well, the covenants brought forth a right that was applicable to the people of the state party, that was applicable to the citizens of the United States of America and Canada. A human being must submit to the designation of citizen and subject, that artificial person in law, in order to work, and it is that designation, that role, which has been forced to contribute to the society. It is not a human being in law that is being taxed or forced to contribute, but the artificial person. When you study Section 26 of the U.S. Code, and when you study the Income Tax Enactment of Canada, you're going to see that we're rendered employees or officers of the corporate body called Canada or America. And that's how they're taxing us. Now, this is why the covenant speaks here of the player or designation is that of people and not of a human being, everyone. When they talk about the right of not having to contribute, this right is applicable to the people. This right is applicable to the citizen. As citizen, you can exercise that right. In the International Covenant on Civil and Political Rights, Article 1, it says all peoples have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. All peoples may, for their own ends, freely dispose of their natural wealth and resources, without prejudice to any obligations arising out of international economic cooperation based upon the principle of mutual benefit and international law. In no case, in no way, in no how, with no law, may a people be deprived of its own means of subsistence. As one of the people, one inhabitant in the state party's territory, you have the right to decide if you will contribute to the social, economic, and cultural development of the United States of America. And in no case, in no way, under no circumstances, can you be forced to contribute to the economic growth or development of your state or America. Your means of subsistence that you earn, gain, and pursue by free choice, as the law declares, is yours to do with as you please, and there is no domestic law that can be created which would force you to turn over this wealth to a society based upon the principle of mutual benefit. When you look into the international law where the obligation comes out, in Article 47, it says nothing in the present covenant. So nothing in the covenant allows them to place a limitation upon this right. Nothing in the covenant allows them to abridge this right or deny this right. Nothing in the present covenant shall be interpreted as impairing the inherent right of all peoples to enjoy and utilize fully and freely their natural wealth and resources. No one has the right to make a claim upon what you earn and what you gain unless you contractually agree or enter into contract with them. Again, we are seeing it is stated that nothing in the covenant can force a person, peoples, to turn over their wealth. There is no provision that will be found in the covenant that America can transfer into domestic law that will force the citizen to turn over its wealth and resources. The choice is the individual's. The covenant grants and recognizes the choice. Nothing in the covenant impairs this right, and no limitation can be placed on this right, and the state party must express this right. International covenant brought forth the right of the people to choose. America was under obligation to fulfill this measure and to bring forth this right in domestic law, just like the other rights that we saw tonight. Well, here's one. You've got to bring it forth in domestic law, and the obligation comes out of Article 2.2. If it's not already provided for in your existing laws, you promise to undertake the necessary steps in accordance with your constitutional process and with this provision of this right to give effect to it through laws or adopt other measures. So America, the states, had to express this right in one of three ways. They had to adopt it through the constitutional process, adopt a law, or provide another measure. Well, when we looked into the constitutions of America and the constitutions of the state, we saw other rights that were expressed in there, but we didn't say these particular rights. How come? Well, when we look back into the Constitution of California now, in Section 21, it says the enumeration of certain rights shall not be construed to impair or deny other rights retained by the people. So with this operation of law then, it's saying that the enumeration or the listing of certain rights and freedoms here in the Constitution of California doesn't mean that we're going to deny or we're going to impair the existence of other rights. So if you understand that there are other rights in operation, then you can hold the executive powers, and in your state it would be your governors, but you could hold them accountable. Again, in the Constitution of Ohio, Article 20, powers reserved to the people. The enumeration of rights shall not be construed to impair or deny others retained by the people. Constitution of Michigan. The enumeration in this Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So this is the operation of law that they used. They provided another measure, you see. This is the operation of law that they used to fulfill their obligation concerning the right not to have to contribute. The international law brought it forth. It said nothing in the present covenant will force you, domestic party, to force these individuals to contribute their natural wealth and resources through taxation, through a principle based upon mutual benefit. And you got to provide the measure. And did they want to express it directly in the Constitution? No. Why? Because if you went and you began to read this in their constitutions, maybe we would see it, we would wake up, and we would say, what's going on? So they didn't express it directly. They provided another measure. The other measure is, they said that, again, North Carolina Constitution, that even though we listed certain rights in this Constitution, it doesn't mean, or don't take it to mean, that we are denying or impairing the other rights that you retain, that you have. And remember, when we're talking about rights, here we're talking directly about rights. And when we use the term people, now we're talking about the men and the women. Now we're talking about the inhabitants. Why? Because we're dealing with rights. We're not dealing with the government body. So the Constitution of New Jersey, the enumeration of rights and privileges shall not be construed to impair or deny others retained by the people. And in Alaska, again, Article 21, the enumeration of rights in this Constitution shall not impair or deny others retained by the people. And the same thing is said in the Constitution of Illinois and the Constitution of Georgia. But in Georgia, it specifically brings it forth in both capacities. It says in Article 39, the Constitution does not deny other universally recognized rights and freedoms and guarantees of the individual, who's that? The man or the woman, and citizen, which are not specifically stated, but are the natural outcome of principles contained within the Constitution. These particular rights were given force or effect through invoking the operation of law we just spoke about. The executive and legislative parties did not want to directly enumerate these rights in the Constitution, for they would be taking the chance of these rights being understood in a simple manner. They did the same thing to us in Canada under Section 26 of the Constitution Act 1982, where it states the guarantee in this charter of certain rights and freedoms shall not be construed as denying the existence of any other rights or freedoms that exist in Canada. And do you want to take a guess what rights and freedoms they didn't list or enumerate in the Constitution Act? Well, I can tell you they listed Article 19, just like they listed it in your Constitution Act, and they listed Article 21, just like they listed it in your Constitution Act, and Article 9, but they didn't list Article 16, and they didn't list Article 1, and they didn't list Article 47. Why? Because they wanted to hide this right from us. But they secured it through the provision of another measure, just like your constitutions did, stating that even though we listed certain rights in the Constitution, it's not to be taken that you as a man or a woman, or even as a citizen, that you do not possess other rights and freedoms that we are under obligation to respect and ensure. When you look into the Constitution of Florida, Section 23, you read the right of privacy. Every natural person has the right to be let alone and free from government intrusion into the person's private life, except as otherwise provided herein, except if you submit to them through their operations of law. Basically, what that's expressing is your right to liberty. You have a right to be let alone and free from government interference. Now, when you read a judgment here, Thomson Newspaper Limited versus Canada, it says, while individuals, as a rule of law, have full legal capacity by operation of law alone, artificial persons are creatures of the state and enjoy civil rights and powers only upon the approval of statutory authorities. When you operate as a person, as a citizen, your rights, your privileges, your obligations flow through regulations, flow through enactments. Now, the individual may stand upon his constitutional rights. You and I, we can stand upon our constitutional rights of our full legal capacity. And he owes no duty to the state, since he receives nothing therefrom, beyond the protection of his life and property. Now, you see, the government, when you're standing in your natural capacity, still owes you the obligation to protect your life and property. His rights are such as existed by law of the land long antecedented or before the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. He owes nothing to the public so long as he does not trespass upon their rights. If you do not do harm to another or to their property, then you owe no obligation to the public. If you do not operate from the capacity of a class of persons, then you owe no obligation to the government. Now here, remember, here it says these rights, okay, have existed by law of the land long before the organization of the state. And in the beginning of this video, remember I shared with you in one of the Constitution Act, it said these natural rights and freedoms have been in existence, and the reason why the government was created was to protect these natural rights and freedoms. Now, our fundamental rights and freedoms, our common law rights as men and women, are still preserved within their own laws. They're still there, they're just hidden from our eyes. And after learning all that you learned tonight, I can share with you, you know what? Your government had the obligation to teach you all this. When you went to school and you had an education that was given to you from the government, Their obligation was to first teach you about your fundamental rights and freedoms and how to operate them within, you will say, the corporation or within the country that you're living in. And then secondarily to teach you how to operate rights and freedoms or from the position of the citizen. And they never did. They just showed you how to operate from the position of a citizen, and they stripped you and they took away from you all of your fundamental rights, your natural rights and freedoms, because they wanted to put you in servitude. Again, government was created initially to protect our natural rights and freedoms. But power corrupts. We have to understand power corrupts, and that's what's happened to our government bodies. They got power, they started to become big monetarily, and they took over. But it doesn't matter. As one individual standing on your state party territory, when you begin to learn and understand these operations of law, how to express and stand under your fundamental rights and freedoms, your common law rights, you will find your remedy. Though you'll look around you and you'll see thousands that are bound to the system, still in ignorance, not understanding that they have fundamental rights, common law rights, human rights and freedoms, you will be able to express them. Why? Because you did your due diligence and you took time to learn them. They are there. They are present. We can exercise them. Don't let individuals tell you otherwise. Don't let them pick your pocket. Our rights, our common law rights, are contained within the laws. The remedy is there for us to express. The courts of America do have the power to, to exercise the administration of justice on your behalf. Now, in order to have these rights respected, you must seek after the administration of justice to have remedy against the executive powers. So if you want, you can go to the information page at eternallyaware.com, and there you can acquire some tools to help you understand your fundamental rights and how to give effect to these rights domestically. You are able. The provisions of law, the operations of law are there. You simply must learn them. And also, while you're there, don't forget to surf the United States page. I've been building this page and I'm going to keep on building it. So, eternallyaware@yahoo.com is my email. And if you're looking for information concerning what I've been sharing here, again, go to the information page at eternallyaware.com. You'll see some indication concerning the United States of America. I hope you enjoyed this video.